Hey everyone, James Reeves, believe it or not, Esquire. I'm licensed to practice in Louisiana, Florida, Alabama, Mississippi. I also practice for U.S. Law Shield. They're one of my clients. I'm the U.S. Law Shield independent program attorney for Mississippi or Louisiana. So if you get in a self-defense incident in Louisiana or Mississippi, turns out, for better or worse, I'm your lawyer. I've defended Law Shield clients many times over the past, I don't know, 6-7 years, however long I've been working with them. If you would like a couple of free months, I've got a promo code for you, NGGC, like Neutral Ground Gun Company. You get a couple free months. I get 20 or 30 bucks if you use that code to sign up. I would love to have you as a possible client. Not really. I don't want you as a client. I want you to have the service, but I don't want you to get in a situation where you need me as representation. But if you need someone, I will be glad to be that person for you. Let's talk about an issue that we've discussed in the past, although in the context of the AR-15. A lot of you probably saw the how an AR-15 can send you to prison video that I made a few months ago, where we looked at, God, I think it was like almost a year ago, where we looked at this study out of Texas, very well-researched study, where they had these mock jurors and they showed the mock jurors the weapon used by the homeowner, and these mock jurors were reviled by the AR-15. Same set of facts. They're like, okay, the guy who uses the shotgun or the Mini-14, he's okay. Same set of facts. The guy who uses the AR-15, throw him in jail. Today, we're talking about the AK-47 and how it might be even worse. But before we even get into this, I want to backtrack a little bit. Somehow I became the don't use an AR-15 to defend yourself guy when it's not like that at all after that first video. As I said in the AR-15 video, I still use an AR-15 as my primary home defense tool, although I have a 1301 also kitted up for that as well. And from a legal liability standpoint, that might be the better choice. The point is, I'm not telling you what to do. I am not making any recommendations. I am just presenting actual facts from actual cases for you to consider in terms of legal liability. On top of that, I'm telling you that owning an AR-15 or owning an AK-47, that doesn't mean you're going to jail. Only showing you what a prosecutor might try to do, and you can make that decision for yourself. You've got viewers reading a little bit too deeply into my videos, and worse, you have internet gun lawyers on social media telling me that I'm telling people that owning an AR-15 means they're going to federal pound me in the ass prison. It's not like that at all. I'm not your lawyer. This is not legal advice, just facts and cases for you to consider when you make your decision. Now that that's all clear, let's talk about the AK-47. In my opinion, AK-type rifles might be more dangerous from a legal liability perspective than the AR-15, just because it might be the one and only gun actually scarier than the AR-15 to the layperson. You say AR-15, they might think Kyle Rittenhouse. You say AK-47, and it's, ooh, Osama bin Laden. Allahu Akbar. This negative association is so strong, it's irresistible to prosecutors. Let me tell you about State versus Ndolo. State versus Ndolo. Ndolo? As probably the prime example. Ndolo, I guess. I'm just a country lawyer. Ndolo was moving from Texas to Arizona. He hires this transport company to haul his car. When the car arrived, it was allegedly scratched. Naturally, Ndolo was pissed. But he refused to pay the movers. When Ndolo tried to get his car back, one of the movers stepped in to stop him. Ndolo grabs this guy by the throat, shoves him against the car, drives his car into his driveway. While the movers called 911, Ndolo grabbed a .22 rifle, fires off 4 warning shots into the air saying, hey, get off my property. These guys back off, cops show up, Ndolo puts the rifle down, he gets arrested. The whole situation involved a .22 rifle, some yelling, questionable decision to crack off some warning shots, but then the prosecution pulled a classic prosecution move. During a search of Ndolo's house, police found a loaded AK-47. Keep in mind, AK had nothing to do with the incident, wasn't used, it was in the house. Defendant never touched it, never even talked about it. No one mentioned it until the cops found it in his house later. But the prosecution could not resist. They brought it into court. They argued that it showed that Ndolo was looking for a violent confrontation. He was prepared. He was AK-47 edging. Now, the defense tried to keep the AK out of court, pointing out that it wasn't involved at all, but the judge allowed it, and the prosecutor made sure that the jury knew that the defendant owned this big, scary AK. Why? Not because it really proved anything relevant to the case. It was probably just to make the defendant look bad, although the prosecution pretextualized it by saying that it showed the defendant was the kind of person to have a gun without a legitimate self-defense concern. The jury convicts the defendant of felony aggravated assault, sentences him to 7.5 years. Here's the kicker. Even though, on appeal, the appeals court agreed that the AK was irrelevant and should have been excluded from evidence, they still upheld this conviction. Why? Because the standard for the improper introduction on most evidence issues is the harmless error standard. If he was going to be convicted anyways, and the AK evidence didn't really matter much, no harm, no foul, basically. There was a concurring opinion from an appellate judge who said, look, I agree with this ruling, but I want to address what I see as massive government overreach here. He said, I'm quoting it, nothing in the record even suggests it was unlawful for Ndolo to possess the AK-47. The AK-47 was neither present during the incident nor played any role in it. The AK-47 was inside the home, and there's no evidence that he attempted to enter his home during the incident. But let's be honest with ourselves here. Do you think the jury wasn't influenced at all by the fact that this guy owned an AK-47, the layperson jury? No one can say they weren't. That gun planted an image, likely planted an image in their minds that had nothing to do with what actually happened. So was he guilty? Sounds like it. Resorting to choke slamming a mover and cracking off 4 rounds from your Marlin Papoose or whatever because he scratched your Altima might be a little unhinged. He probably was guilty. He probably should have gotten some jail time, but the state did him dirty, and they got away with it, in my opinion. I've got 2 more cases not nearly as compelling as that Ndolo case, but they're worth talking about. Anderson v. State. Shoe was on the other foot. The defendant, Anderson, shoots one man in the legs 8 times. I'm sorry, but LOL. And he fatally shot another guy in the back after an argument in Savannah, Georgia. Anderson said, hey man, I was defending myself, and I'm going to introduce this photo of an AK-47 that was found at the home of one of the men who was in the car with one of the guys I shot before the shooting. Anderson argued that this gun, it could have been in the truck during the shooting, and someone other than him might have been armed, so he was in legitimate fear for his life, acting in self-defense. But no one saw anyone but Anderson with the gun. There was no evidence that the AK-47 was present or had anything to do with this shooting. The trial court excluded the AK-47 evidence, reasoning that it lacked a direct connection to the crime, and introducing the AK-47 into the trial would have required the jury to make multiple unlikely mental steps that the rifle may have been in the truck at some point. Anderson was aware of it and that it caused him to act in self-defense when there was really nothing there. The court found that the risk of confusing the jury or prejudicing the jury outweighed the limited probative value of the evidence. Ultimately, while the exclusion was the right call, it's another example where the fact that someone connected to the case owned an AK-47, that was sought to be used as a distraction for the jury to say, oh my God, look at my client who shot these 2 men. He was scared because one of the guys that was with one of the 2 men owned an AK-47. Look at this big scary AK-47. Got one more for you, Davis v. Carter. Not a lot of facts in the record in this case, so I don't really know what happened. Jeffrey Davis was convicted of first-degree murder. At trial, the prosecution introduced evidence that he had owned an AK-47 6 months before the crime, and it sounds like it had even been seized or something. From what I can gather from the record, the AK-47 wasn't at the scene, wasn't connected to the incident. It was just an AK-47 that this dude owned 6 months earlier. Davis argued on appeal that showing the jury that he had an AK-47 was a due process violation because it had nothing to do with the shooting. It made him look bad. It was prejudicial, suggesting to the jury that because he owned an AK-47 6 months before the shooting incident, he was the kind of guy who would be a murderer. And honestly, he might be right, although I'm just speculating because there's, again, not a lot of opinion, not a lot of factual background in this decision. That said, he lost the appeal for procedural reasons. He didn't properly appeal. So the appeals court never actually addressed his argument or the AK-47 evidence, but the state did bring it up at trial. Classic example of using unrelated evidence about an AK-47 to smear someone. The jury hears AK-47, they start thinking the dude's in ISIS. Did this man murder someone? Probably. Should he be in jail? I'm sure. But the point is that the state will go out of their way, or they may go out of their way, to make sure that the jury knows you own an AK-47 even if you don't have it anymore. These 3 cases, pretty extreme examples. I'm not telling you that owning an AK is going to land you in jail or be used against you in court necessarily. I'm just telling you It could be. These cases that I've cited involved 2 murderers and a dude who got violent because his car got scratched. These aren't your castle doctrine, cookie cutter, home intruder with a ski mask and no pants on self-defense cases. Don't read too much into them. Owning an AK-47, totally legal in most states, but it could be a liability in court. Prosecutors will do anything they can to sneak that information in front of a jury to make you look like a dangerous, horrible person. Even if it's irrelevant, even if you've never used it, even if you don't own it anymore, it's possible the prosecution might try to blow up a Facebook post of you with your Zastava and print it out at Kinko's, because depending on your jurisdiction, once the jury hears the words AK-47, you could be starting at a disadvantage. And bear in mind that if you actually did use one in self-defense, it would be State's Exhibit A. You're not getting out of that. There's no way you'd be able to exclude your trusty AK from being paraded in front of a jury. So if you're ever involved in a self-defense situation, just know that simply owning an AK could work against you in ways you wouldn't expect. I'm saying it one more time. Don't overreact. Just be prepared and be smart. If you have any questions, leave them in the comments. This is not legal advice. I'm not your lawyer. Thank you. I'm out of here. Goodbye.